Welcome to today's program titled Navigating the Return to Work, Vaccines, COVID-19 as a Disability, OSHA Enforcement, and more. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Scott Hecker. Scott, please go ahead.
Thanks, Kate, and thanks to everyone for joining us for today's webinar. I'm Scott Hecker. I'm a senior counsel in Seyfarth's DC office. I joined Seyfarth from the Occupational Safety and Health Division of the U.S. Department of Labor's Solicitor's Office, and my first day with the firm coincided with the first week everyone went fully remote. So I've been closely following COVID and the pandemic from the very beginning. I work with employers on workplace safety, wage and hour, government relations and policy, and government contracting issues. I'm honored to share the webinar stage today with the 27 Yankees of COVID subject matter experts. First, we have Carla Grossenbacher, who is a firm partner, chair of our DC office's labor and employment practice, head of the firm's workplace privacy team, and co-chair of the firm's workplace biometric privacy, compliance, and litigation group. I've suggested to Carla before, however, that her most important role is serving as my supervisor. Carla is at the forefront of COVID counseling and thought leadership and has been throughout the pandemic. During today's webinar, she's going to share her deep knowledge regarding the ongoing COVID vaccine issues at the state level. Also with us today is Kristen McGurn. Kristen is a Boston partner, co-managing partner of that firm office, and co-chair of the firm's healthcare practice group. Her knowledge of the healthcare sector and her experience with EEO issues have made her an invaluable counselor during the pandemic to firm clients. And to those of us, I'm raising my hand, within the firm who sometimes need comprehensive but clear tutoring on the inner workings of the healthcare industry. Very much appreciate that, Kristen. Kristen is going to focus her presentation today on the CMS vaccine mandate directed at facilities that receive Medicare and Medicaid funding. We also have Condon McLaughlin with us today. He's an L&E partner in our Chicago office. He's got extensive EEOC experience and has been a go-to resource for clients and the media during the COVID-19 pandemic. Today, Condon will discuss the implications for employers concerning COVID-19 being treated as a disability under the ADA. And I'll speak about OSHA's ETS and what OSHA may be doing going forward now that that ETS is no longer effective, and also discuss the federal contractor vaccine mandate and where that stands. I think to kick off the substantive portion of our presentation, I'm going to turn it over to Carla.
Thanks, Scott. Hello, everyone. My topic is vaccinations and exemptions under state law. So let's advance the slide one here. Perfect. So when we talk about the return to work in the office, a topic that naturally comes up is, should I require everyone to be vaccinated now that we're coming back to the office? And sometimes the question is posed as in terms of whether you should have everyone vaccinated, whether you should just have those who are coming into the office vaccinated, whether you should just have people who interact with the public be vaccinated, whether you should have people who visit clients on behalf of the business be vaccinated, or perhaps they need to comply with client requirements if they serve clients and customers in the healthcare industry. So it's not an easy topic if you don't already have a vaccine mandate in place. And when you think about putting a vaccine mandate in place now, it's a little bit of a different analysis than it's been in the past. So right now, the federal contractor mandate has been stayed on a nationwide basis. The OSHA ETS has been withdrawn. And there are clients who, when operating under either the OSHA ETS or the federal contractor mandate, we're comfortable taking the position that state law compliance, and by that I mean compliance with laws that place restrictions on employer vaccine mandates, could be avoided on the theory that the federal requirements superseded or preempted the state laws. But now that the OSHA ETS has been withdrawn and the federal contractor mandate is on hold, at least for now, and Scott will talk more about all of that later, we need to think about what are the restrictions on vaccine mandates by employers under state law. So let's go to the next slide. Since it's been a while since the EEOC has put out its guidance on mandatory vaccinations, sometimes our clients have questions about whether anything's changed and can they still mandate vaccines. Nothing has changed about the analysis under federal employment law from when the EEOC first articulated it. Any employer can mandate the COVID vaccine for their employees as long as they provide accommodations in compliance with the ADA and Title VII for religion and disabilities, and as long as the employer or its agent is not the one administering the vaccine. So essentially tell your employees, go get vaccinated wherever you want. The other piece that hasn't changed also under federal employment law is whether employers can request or require employees to provide proof of vaccination. The EEOC has said that's not a disability-related inquiry under the ADA, so you are free to ask that question and require proof of vaccination from your employees under federal employment law. But you have to now consider state law. So let's go to the next slide. There are currently 13 states with laws or executive orders that undercut in some way an employer vaccine mandate. I've listed them for you on the slide. All of the laws are different, but yet similar in the sense that they provide mandatory exemptions to an employer vaccine mandate, or at least most of them do. For example, you have some outliers with Montana, which is essentially a non-discrimination law. You can't make distinctions between the vaccinated and the unvaccinated in Montana, so you can see how that would effectively make a vaccine mandate unenforceable. And you have Tennessee that has a law that says you can't compel through adverse action someone to provide proof of vaccination. But the other laws all have stated exemptions. And the interesting thing is that they don't allow for an undue hardship analysis like you would have under Title VII or the ADA. Some of the laws also explicitly prohibit follow-up questions, sometimes to all accommodation requests, sometimes just to religious ones. And that's in response to, there have been many articles during the pandemic when employers were rolling out their vaccine mandates about the questions that employees were being asked about their religions. So some of these state legislatures have specifically prohibited those types of questions. There are additional laws being proposed all the time. I curate a survey on this topic for the firm, and I can tell you that we get new bills all the time on this topic, and new ones being sent. Last week, one was sent to the governor in Wisconsin, who vetoed it. There's another law that's sitting on the governor's desk in Mississippi, awaiting action from the governor. So this landscape is changing right under our feet as we're trying to set up a compliance scheme. Let's go to the next slide. So I'm listing on this and the next slide, and I believe the slide after that, the various type of exemptions that are available under state law. And you'll see that they go far beyond what is allowed under federal law, religion and disability, to include things that are medical conditions perhaps, but not necessarily disabilities. And also, the first two slides have to deal with what I'm loosely categorizing as medical exemptions. So someone's willingness to provide a negative antigen test once a week. Someone saying that it would be injurious to their health or well-being to be vaccinated, or injurious to the health and well-being of someone who lives with them. Try to wrap your head around what that scenario would be. Let's go to the next slide. These are additional categories of medical accommodations that are available under state law. prior immunity to COVID is one that appears frequently in a number of these state laws on the theory that it is as protective or more protective as a vaccine for some individuals. There are exemptions for pregnancy, bleeding disorders, if you're immune compromised, if you have an allergy. Now, no one state has all of these, but I'm trying to give you an idea of how far beyond the scope of federal law some of these states go. Let's go to the next slide. So some of the state laws also provide for an exemption based on religion. And you might think that's superfluous since they are already entitled to that kind of accommodation under federal law, but it's not, because like I said in the introduction of the subject, there's no undue hardship analysis. There's no follow-up questions under some of these laws. So they're making it a point of state law compliance that the person has a religious accommodation right, but that it can't be refused in the same way it could be under federal law. Some of the state laws go beyond religion to philosophical and moral beliefs, any reason of personal conscience. One even provides for just a sincerely held personal belief, which is not a defined term and could mean almost anything. So again, these state legislatures are trying to broaden the circumstances under which the citizens of their state can ask for an exemption from an employer vaccine mandate. Let's go to the next slide. So a little more detail on the interactive discussion, follow-up questions, and undue hardship piece. Generally speaking, not allowed for under these state laws and expressly prohibited under some. The exceptions are Indiana, which says that the employer simply must comply with Title VII when it comes to religious accommodations. And as you know, our interpretation of Title VII and what is stated in that law is that you can ask follow-up questions under the EEOC guidance, and that you can deny an accommodation request based on it placing a de minimis burden on the employer. Arkansas and North Dakota don't have any express statement one way or the other about whether follow-up questions can be had or whether an undue hardship analysis can be employed. So it's a little bit of an open question in our view under those two states. Let's go to the next slide. So I've been talking about employees and employee rights to accommodation under these state laws, but some of the laws do apply to applicants. I've listed on the slide for you the 6 states in which the law really expressly refers to employees. And in those states, when you view the preamble of the law, it's clear that the legislature is trying to protect people who are incumbents, who have jobs, and they don't want them to be terminated from those jobs. They're less concerned with new hires willingly applying for a job where there is a vaccine mandate, and view it differently when one is placed on someone who's already in the position and didn't know this was going to be a requirement. So some of these laws are expressly written only to apply to employees, but there are others that expressly reference that they cover applicants as well. Let's go to the next slide. So what about enforcement? Many of these laws don't have any sort of penalty listed in them. Others have private rights of action. Others have enforcement by the Attorney General. Others provide for judicial review. Others have an appeal process. It's all over the map in terms of enforcement. And then you have some, like Utah's a good example, that just don't say anything about what happens to you if you don't comply with the law. There's always figuring in the background this notion that there could be, if you terminate someone under one of these state laws and there's no express penalty, query whether that would give rise to some sort of wrongful discharge in violation of public policy cause of action from the person who's been terminated. So we have yet to see how that may play out anywhere. Let's go to the next slide. So a few best practices to close out this section. First off, you want to make sure, especially if you're a nationwide employer, that your process for accommodations is compliant under all the state laws. And I've told you enough about these laws to, I think, make clear that a one-size-fits-all solution is not really possible here unless you just want to give your employees every single exemption that's available under every single state law, and no one wants to do that. So it's really got to be a state-by-state process. So in combination with that, it'll be important to determine where your employees work and live. And that sounds basic, but it's harder than you think if you sit down and try to do it, especially with all of the geographic shifting around that we've seen during the pandemic of employees moving to other states. So you need to review where your employees are. And it could be that you take the position that I'm the employer, you're assigned to a work location in this state, and if you move somewhere else, that doesn't matter. Query whether it would matter under one of the state laws that are designed to protect the citizens of that state. You could also ask the employee in the accommodation request, where do you live and work, just to make sure you understand what they're thinking in terms of which law they have the protection of. And then, of course, you want to train your accommodation team. You want to make sure they understand what the requirements are under state law. I haven't gone through all of them. There are some states that have required forms, and employees have to use the required forms. You need to make sure they understand what's available under state law, whether they can ask follow-up questions, whether they can use an undue hardship analysis. So training is going to be key here for both the HR team, the legal team, just to make sure that everybody understands the compliance landscape. I will look real quickly to see if there are any questions that came in. Okay. I'm seeing that there might be a couple. I'll respond in the chat, and if there's time at the end, we can address some of them, especially those that might be repeats live during the program at the end if we have time for that. But now I will turn things back over to Scott.
Thanks, Carla. Appreciate it. I think we are going to, Kate, jump to OSHA at this point, or do you want to go to Condon?
Go ahead and jump to OSHA. Go ahead and jump to OSHA, Scott.
Let's do it. Okay. Kate, if you could throw up the slide that talks about the status of OSHA's ETS, just to sort of set a baseline here. And we can go to the next slide, that's the substantive slide there. As folks probably know by now, on January 13th, the Supreme Court issued twin opinions going in opposite directions.
I had to be on the program for a minute. So that's what I need, that post-COVID conditions. Post-COVID conditions. This is last updated in September, I think.
Hey, Condon, could you mute when you get a chance? So the status of OSHA's ETS, it's defunct. It was basically an injunction was re-entered by the Supreme Court on January 13th, saying that applicants for emergency relief were likely to succeed on the merits of their claims, in that OSHA exceeded its authority to issue the ETS. OSHA explicitly stated when it withdrew the standard, when it said we're not going to enforce this thing anymore, that they would still use it as a proposed rule for a permanent standard, or they still could do that. We haven't seen any forward motion on that. In fact, OSHA's seemingly put resources on its COVID healthcare permanent standard that's based on its healthcare ETS, rather than the vaccination and testing ETS. You can imagine that the same issues that plagued the ETS with the Supreme Court, where they found it was sort of overbroad for a workplace safety agency, could have impacted any permanent rulemaking there as well. So OSHA will have to consider whether it believes it can go that route longer term. On February 18th, the Sixth Circuit, where the merits proceeding was going on, granted the government's motion to dismiss the petitions challenging the ETS. So that effectively ended the merits case regarding the vaccination and testing emergency temporary standard. If we go to the next slide. Again, just noting, and Carla mentioned this, the Supreme Court's decision did not impact a private employer's ability to implement its own mandates. But employers should and certainly are considering how a mandate or a vaccination policy more generally works for their workforces and in their workplaces. So you can institute a vaccine policy, a mandatory vaccine policy. The Supreme Court's decision did not implicate that. It just said OSHA overstepped its authority in trying to bind employers to a vaccine mandate. Secretary Walsh, the Secretary of Labor, certainly disappointed and said that regardless of the ultimate outcome of these proceedings, OSHA will do everything in its existing authority to hold businesses accountable for protecting workers. And he said that right after the January 13th decision, indicating that OSHA would use its existing tools to continue its COVID-related enforcement. And if we could go to the next slide, Kate. And then actually, let's go to the next substantive slide to talk about what is next from OSHA. So as we just discussed, the ETS, the vaccination and testing ETS, was withdrawn on January 25th. No state plans have their own vaccine or test rules in place. So they're unlike the sort of state limitations that Carla discussed, no states have kind of taken it upon themselves to implement anything similar to the vaccination and testing ETS that OSHA issued and tried to maintain at the federal level. As mentioned, it's still a potential permanent, a proposed rule for a potential permanent standard, and that's one of the functions of an emergency temporary standard, is to serve as a proposed rule for a permanent standard. There is supposed to be a time limitation on that. A permanent standard is supposed to issue under the statute, the OSHA Act, within 6 months of the ETS's publication. We did not see that with the healthcare ETS and any healthcare COVID permanent standard. In fact, that ETS, technically, we read the statute as saying it expired on December 21st of 2021, that should be, because we haven't gotten to 2022 December yet. But in 2021, and OSHA withdrew all but the record-keeping provisions of the ETS at that time, I believe on December 27th, indicating that it would move forward with a permanent COVID-19 healthcare standard using the ETS as a proposed rule. It's also looking at an infectious disease permanent standard, but for right now, OSHA has actually reopened the rulemaking record on the healthcare standard, the COVID healthcare standard, with the ETS again as the basis. Comments are due by the end of this week on that, actually by Friday, the 22nd. And there has been an announced online hearing. Initially, it was scheduled for April 27th and to continue as necessary after that. OSHA has now, presumably based on the number of folks who want to testify and present evidence at that hearing, it has expanded the hearing. It is set for the 27th through the 29th of April and May 2nd. So you're looking at 4 days of an online hearing concerning this permanent COVID healthcare standard. And a number of the items that OSHA highlighted in announcing the reopening of the record included seeking comment on things like alignment, how the ETS or how the permanent standard should align with the CDC's recommendations for healthcare infection control procedures, how the permanent standard could provide more flexibility for employers, some removal of scope exemptions, tailoring the controls to address interactions with people who have or are suspected to have COVID, employer support for employees who wish to be vaccinated. Now, the ETS, the healthcare ETS, did not have a vaccination mandate, and presumably we won't see one here, though Kristen will talk about the CMS regulation and its vaccine mandate that probably has some overlap with these covered facilities on any COVID permanent standard in the healthcare space. They also wanted to look at limiting coverage over construction activities in healthcare, record keeping and reporting provisions, requirements based on community transmission levels, which obviously is somewhat related to CDC's approach to things currently. The evolution of COVID-19 into other strains, we've seen that. We've seen iterations like Omicron, BA2, BA2.12.1, BA2.12.2, I think we're at now. So we've certainly seen that we need to adjust our approaches This goes along with Carla's mention of no one-size-fits-all policy. Different workplaces present different potential levels of transmission, potential exposure, potential risk. And I think that's also part of what underlied the Supreme Court decision saying that the vaccination and testing mandate was overbroad because it sort of attempted a one-size-fits-all approach to a varying problem. And again, the OSHA also, through this reopening of the record, wants to consider changes in health effects and the risk of COVID since the ETS was issued. OSHA did note that the ETS comment period took place sort of early before a lot was known about Omicron and other variants. So OSHA wanted to make sure it's operating, or wants to make sure it's operating in this permanent rulemaking with up-to-date scientific and other evidence. If we could go to the next slide. And in general, so COVID-19 in the Biden administration, as we noted, Secretary Walsh pointed to other tools that OSHA can use here. Some of the ways that it's getting out and inspecting COVID exposures in the workplace are through complaints, responding to complaint letters. Definitely on-site inspections are picking back up. There were some limitations, of course, given the potential for exposure to OSHA and its workforce that limited its ability to do on-sites, but we're in a place where now inspectors are going to be going on-site more frequently, we anticipate, and we're seeing that. And OSHA has, OSHA handles a number of different whistleblower statutes, but 11C is the OSHA Act's provision. And we expect that will be used as a way and encouraged as a way for OSHA to become aware of potential COVID issues. This administration, the Biden administration, has certainly encouraged that kind of active employee participation in the safety arena as well as other arenas. You'll see sort of anti-discrimination, non-retaliation provisions in a lot of their executive orders or rulemakings. To ensure that employees are not chilled from, or the goal is to ensure employees are not chilled from reporting these violations. So we can anticipate that those may increase, those types of claims and whistleblower claims may increase. Further, there is the potential for employees to, say that they cannot work in certain imminent danger circumstances where they're presented with an unsafe work environment. You could see those kinds of claims. And now that we're hopefully, potentially, possibly turning the corner, and people, as the title of this webinar suggests, are really coming back to the workplace, it may be more difficult for an employee to say that COVID in the workplace presents any sort of imminent danger. But that is out there not only for COVID purposes, but it's an existing policy with OSHA about how employers may refuse to work in imminent danger circumstances. If we go to the next slide, I would talk a little bit more about the avenues that OSHA has for enforcement. OSHA has what's called the General Duty Clause, 5A1 of the OSHA Act, which requires employers to provide workplaces free from recognized hazards that could cause serious injury or up to and including death. Of course, OSHA is going to be relying on and looking to CDC and NIOSH, their guidance when considering whether a General Duty Clause violation may exist. There's also guidance that OSHA has issued. It's been up for quite some time throughout the pandemic, really, and that's the link you can see there. That guidance was last updated, I believe, on August 13th of 2021. In mid-March, I attended the ABA's Occupational Safety and Health Committee midwinter meeting where there were OSHA representatives present. And when the question was asked, when will we be seeing an update for that guidance, since it's almost a year old now, the response was soon, and that was all. So we haven't seen it in another month since that conference. We were actually talking before this webinar about what soon means when you put it in an email, and I think here we can wonder what soon means to OSHA. If they had a date certain, presumably they would have said it, but they don't want to bind themselves to a particular date because as we've seen, there's a lot that goes into this. There's shifting landscape here, and they just have not been able to update that guidance and provide a bit more concrete recommendations and advice to employers and employees both. OSHA has also pointed to existing regulations that can be used, that it doesn't have to rely on the now defunct ETS. It can point to respiratory protection standards, sanitation, hazard communication, PPE, personal protective equipment, or record keeping. Just some of the standards that already exist that OSHA has authority to enforce under. It can use those to issue COVID-related citations, and we've seen that, and we can expect more of that. There is a national emphasis policy, meaning OSHA has placed an emphasis on COVID enforcement across the country, and we can expect it to continue asking about COVID issues when it's on site and continue to actually engage in COVID inspections, COVID-based inspections, either in response to complaints, whistleblowers, or just in general asking about it when they're there. OSHA at that same conference did say that its primary enforcement focus is still the COVID-19, and I believe it used the term endemic, though I don't think we're there yet necessarily technically, but it will look to continue to use record keeping and records and enforcement. And we can probably expect more egregious cases. That's high dollar value, serious violations, and willful violations, repeat violations, really enhanced enforcement in this and other spaces under the Biden administration. If we go to the next slide, basically this guidance that we talked about, OSHA has continued to suggest, and we heard about this in the reopening of the record for the healthcare standard as well, that OSHA encourages employers to facilitate employees getting vaccinated, whether that's granting paid time off to get vaccinated or to recover from side effects. That's one way to do it. That was in the ETS and continues to be something that OSHA encourages employers to do to assist and to facilitate vaccination. When looking to CDC guidance on when to quarantine or isolate, distance where you can in communal areas. Masking obviously is a moving target and more at the state level. We just saw a judge in the Middle District of Florida overturn the CDC's mask mandate on public transit and on airplanes. That is something to pay attention to, both on your particular public transit system, or to see whether and how DOJ may come and challenge that ruling. It looks like they're waiting to see what CDC might have to say on May 3rd, I believe, when that order was meant to expire if not renewed. And if CDC decided it was going to walk away, then you may not see DOJ pursue it. But consider that DOJ and the government are certainly looking to retain their authority and don't want to hamstring CDC if we see, knock on wood, a more virulent strain emerge later and CDC wants to reinstitute something like that. But again, as Carla talked about, sort of the differences at the state level, because of the lack of kind of federal guidance or federal vaccine mandates that are operative outside of the CMS reg that Kristen will talk about, you really do need to pay attention to jurisdictional requirements and the particularities of your own, public transit system, the airport you're traveling into or out of. I think most, if not all, airlines have walked back their masking requirements, but that doesn't mean that every airline or every airport will do the same, or that every subway system will do the same. So really, employers and just folks in general should keep an eye on those things in their relevant jurisdictions. Of course, training, making it clear to employees what your policies are regarding COVID, whether you've implemented a vaccine policy or otherwise, and thinking about how you treat visitors, whether you require unvaccinated visitors, all visitors, any visitors to mask, to potentially provide, proof of vaccination. These are the things that you should continue to consider and think about through, not a workplace safety lens generally, but also, an OSHA enforcement lens. And of course, folks on this call and the rest of our workplace safety and COVID task force teams are available to chat about those issues and assist you as you consider them. If we go to the next slide, we have some tools and options. Again, you can consider a number of these, whether you want to have a hard or a soft mandate. Hard would be without a testing option, soft would be with a testing option. How you're going to document that? Are you going to use an honor system? Do you want to continue to use wellness screenings, either management directed on site, taking temperatures, or having employees self-screen and then determine how and when they might isolate? CDC does have I don't know if it's a quarantine, or I think it's a quarantine calculator, because that's more alliterative, so probably that's what they call it. But they issued that not that long ago. We actually blogged about it. You can probably search Seyfarth and quarantine calculator or CDC calculator and determine where to find that. It's a resource that you can use if you believe you've been exposed or you've tested positive, to determine how long and you should quarantine or isolate and what other steps you may take. So those kinds of things are out there for public use. Employers can consider using them and providing some sort of training to their employees about that. The best way to prevent against COVID outbreaks in your workplace is obviously to keep COVID out of your workplace. So it's prudent to consider these efforts and these mitigation protocols. Even though we hopefully are on a downturn, we do see, increased levels of contagiousness, it seems, with these variants, even though hospitalization rates and severe illness rates may be down. Again, you want to consider how these policies will apply to visitors as well. Are there restrictions on who can enter? Should they mask? Are they going to have to go through training, or at least are you going to have signage prominently displayed to ensure that folks visiting your locations are aware of how they should behave and what protocols they should follow and mitigation efforts they should undertake. And if we go to the next slide, I know we have two more presenters, so I'm going to talk relatively quickly about the contractor mandate. If we go to the next slide as well, right now there are a number, and I won't read through all this, but there are a number of appeals pending about stays of the federal contractor mandate. The biggest issue is probably the nationwide injunction that was issued on December 7th of 2021 by the Southern District of Georgia. Since that time, the government has taken a non-enforcement position on the mandate, despite the fact that that judge at one point declined to clarify his ruling, but then said, I'm not clarifying it because it's obvious that it only applied to the vaccine mandate the whole time. And there were other portions to the Safer Federal Workforce Task Force guidance on which the FAR clause that incorporates that guidance into contracts, covered contracts, also required masking and designating a coordinator to oversee your COVID policies. The government had not divided it up in that way. They said, look, we're not enforcing the clause and the guidance as a whole. So all of that has been on hold. Just on April 8th, you'll see at the bottom of the slide there, oral argument took place in the 11th Circuit. I am on the 11th Circuit's website currently as we speak. That no opinion has been issued based on that argument. It's about the nationwide stay in Georgia, and therefore if this panel on the 11th Circuit says, you know what, that stay was inappropriate, or that stay was overbroad because it was nationwide, then there could be changes, and folks will need to think about how they can ramp back up if they have federal contracts that may bring them under this mandate. We'll also have to see how the government approaches it. If we could go to the next slide, and we could probably skip this one. It's we'll make these available. It's more of a timeline of how things went and sort of how GSA and DOD looked at and implemented the non-enforcement position that I just mentioned. But if we go, if we go to this slide about the injunctions, we'll need to see whether the government determines to really push this because of sort of the political status and the epidemiological status of the pandemic at this time. But one thing to note, even without the mandate in place, these injunctions don't impact agency or site-specific requirements for access. So you can have a government agency that still requires access, just like a private employer could, that you need to vax or test to enter a DoD site, for example. The rules continue to evolve. Folks are obviously making changes as the pandemic continues to hopefully wind its way towards conclusion, but we've obviously seen different waves, different approaches, different risk mitigation protocols that have been emphasized at different points during the last 2 years. So it's something to, again, pay attention to. And if you have workers who may be on site at a federal location, you want to be sure that you know what that federal site requires for access. If we go to the next slide, just suggesting some things contractors can do while the litigation is pending, specifically as we wait for the other shoe to drop following that oral argument on April 8th. It's a best practice to be nimble and be prepared to comply, but we don't know, again, how far this litigation will go or what the 11th Circuit will decide after that oral argument. Does the government want to push the federal federal contractor vaccine mandate further, given the status of the pandemic? I think that's something we'll need to see depending on which way the decision goes, and how hard the government decides to push. If one, it wins, and how hard is it going to enforce that mandate going forward? If it loses, is it going to appeal up to the Supreme Court again and try and see, maybe to preserve its authority, as we discussed, with CDC and the masking requirement, but whether political will, political resources are available to kind of push that, and how the Supreme Court would view this. Will it view it more like the OSHA ETS, or will it look at it more like the CMS, or will it look at it more like the federal the federal employee, the federal employee vaccine mandate? We don't know. It's kind of come out in different ways. The Supreme Court has been more receptive, certainly, to private mandates or healthcare related mandates. So just, you want to keep an eye out, see if, read the Bloomberg Law or Politico article or whatever CNN article that comes out on the 11th Circuit decision, and be prepared in the back of your mind to figure out how you would ramp back up to enforce a vaccine mandate for your federal contractor employees, if you have them. I think with that, I will turn it to Kristen to discuss the CMS rule.
Thank you, Scott. Really appreciate that. And I have the honor of reading to you all the thing you're here for, which is the CLE code. Of course, you're here to hear from all of us as well, but the CLE code, for what it's worth to all of you, is SS 3993. That is, again, SS as in Seyfarth Shaw 3993. And my job is to talk sort of about the sole survivor, the rule that SCOTUS upheld when all of the challenges to the Biden administration regulations came down the pike. And, I'm here to talk to those of you in the healthcare industry and adjacent industries who were kind of on the front lines. And while other employers are trying to decide what to do as they, quote unquote, navigate the return and bring their employees back to work, many industries sort of never left, right? And we're back forever. And those industries now are facing, very significant staffing challenges due to the ramifications of COVID and COVID itself, burnout in their ranks. And, just as others emerge from remote work, there are plenty of industries that really never got a large percentage of their workplace out of the office or out of the workplace in the first instance. And so for them, the situation, the landscape has been different. Healthcare is one industry where the vaccination mandate is still driven by federal regulators, and that is pursuant to the CMS rule, which we'll discuss here. Next slide, please. Just before we kind of get into the granularity of this, the other thing to note is that healthcare is sort of the leading industry relating to COVID litigation. We are tracking litigation relating to COVID across the globe, and our COVID task force is, routinely running a tracking dashboard that shows us the nature of the claim and the industries from which these claims are coming. And healthcare started at the top of the list when COVID began, in part because of the OSHA ramifications, workplace safety issues that sort of led the charge initially, but now termination type litigation is at the top of the list, and healthcare as an industry leads the way. So we're watching that, trying to learn what we can from the court's interpretations of the ADA and Title VII in the post-pandemic, endemic, when we get there era. but still stay tuned. We'll continue to blog and report out about those trends for all of you who are watching. For the CMS rule, really what happened here was that in November of 2021, the Health and Human Services published a vaccine mandate that covered all eligible staff working at Medicare-funded, Medicaid-funded, meaning federally funded facilities. And so it set a threshold condition for participation in receiving those funds. Phase 1 was meant to have a vaccine policy in place. Phase 2 was meant to have those employees and others within the work site vaccinated unless they were granted an exemption or if they were temporarily permitted to be delayed per the CDC. Those dates were sort of set in the initial rule. The CMS was then stayed in many states. Texas was the last outlier, holding on after the other states had fallen away, but Texas now too has sort of adopted the CMS rule, and that resulted from the SCOTUS, the Supreme Court, lifting the stay in January of 2022. Next slide. One way to look at this is really, from the words of the court in the case which upheld the CMS rule, but essentially a guiding principle within healthcare and really a part of the Hippocratic Oath, providers taking steps to avoid transmitting this dangerous virus to patients is consistent with the fundamental principle of the profession, do no harm. And so really for the healthcare employers, the CMS rule is an indication, evidence of the fact that that industry was viewed by the Supreme Court as having unique responsibility to seek to prevent outbreaks in the workplace, to protect patients and other vulnerable persons, including visitors and others within the healthcare spectrum. But a significant reason why the CMS rule, we say, was upheld by the Supreme Court. Next slide. This is just to indicate to you all which facilities we're really talking about. The CMS rule covers 15 types of providers and suppliers within the healthcare ecosystem. Those are all listed here on the slide, but really covers a spectrum from inpatient health, acute care hospitals to outpatient ambulatory clinics, community health settings, and home health care. Next slide, please. The CMS guidance issued in January 2022, following the Supreme Court's upholding of the CMS rule, updated the compliance dates, which had by then passed in the states that had challenged the CMS rule, and those required that shots would be completed, the single dose or two doses of a series were completed by March 15th of this year, and covered facilities had to establish that their policy was ensuring that eligible staff received vaccines by that date, and prior to providing any care or treatment within the healthcare facility. The guidance also indicated what constituted acceptable proof of vaccinated status, which could include a vaccination record from the CDC or a photo of the card, documentation from a healthcare provider, an electronic health record supplied to the employer, or state immunization information system records. Next slide. And so, what we have seen since the guidance issued is that enforcement is actually underway. The way in which the CMS rule is enforced is by a review, the standard review that a healthcare facility would be accustomed to ensure that conditions of participation are being met. In each of those conditions for participation, audits that are routine and taking place, COVID now has been added as a checklist to ensure that the policies that are expected are in place and that vaccination status has been obtained and proper exemptions, if warranted, are recorded and tracked. So this CMS, folks who are coming in to do these audits for conditions of participation in Medicare, Medicaid funding are looking for your vaccination plan, assessing whether accommodations are being provided and to whom, tracking your plan for, documenting vaccinations among your staff, and that includes, contractors, employees and medical staff, professionals, and then sets consequences for facilities that are out of compliance, these citations will be based on the severity of the deficiencies found, and typically an opportunity to come into compliance will be offered. But there are risks, significant risks to facilities who are subject to the CMS rule for failure to comply, including conceivably additional enforcement risks and losses of Medicare, Medicaid payment, which for many healthcare facilities covered by the rule are a significant source of their funding. So that's kind of an industry-specific look at where the landscape has left us post SCOTUS rulings, and and as we move our way into the endemic. These are challenging issues for any employer, no less challenging in the healthcare environment, but certainly one of the industries where the state-by-state approach has been that Carla described has been less of a focus on this, and compliance with CMS rule has sort of taken over. And with that, I'll turn it over to Condon, who is going to be talking with us about long COVID as a disability, which we all think is going to be quite a thing for a long time to come. So Condon?
Thanks, Kristen, and good afternoon. Next slide, please. Throughout the pandemic, we've had the law trying to follow science, medical developments, many of which were incredibly fast-paced, unpredictable, horrifying, and confusing. And the law, at least until the executive orders, some of which were more successful than others, the law plodded along. Now, both the law and medicine are going to enter a time, assuming that the pandemic stays, if not in extinction, at least in remission, where there's a great deal of uncertainty, both in the medical field and the legal field, in what to do about what is often called long COVID. One condition is someone's disability, and in other views, it's no such thing at all. And the EOC guidance is a game effort at trying to clarify what is inherently unclear. The CDC guidance is somewhat better, and the CDC is engaged in ongoing study of this condition. But exactly what it is and what to do about it is something that's going to be discussed both in courts, at the EOC, and doubtless in the workplace as people request accommodation. Just a little bit more about what is this condition called, because it goes by a great many names, but they are really largely the same variety of things. So I'll come back to that. Other terms are post-COVID, long haul COVID, hyphenated, post-acute COVID-19, long-term effects of COVID, or chronic COVID. And then there's long COVID, which is what the CDC usually calls it. That's long, lowercase, COVID, all caps, no hyphen, at least in the versions that I've seen. So what is this about? Well, these are after effects of having had COVID, having been affected with COVID-19. You may not have known it. You may not have been symptomatic, but you could still, in spite of that, have long COVID. What am I talking about? What is this exactly? Well, it's an incredible variety of symptoms. They are numerous. They are somewhat seemingly unrelated, and they are certainly wide-ranging. I'm going to read them because the variety of them and the inherent confusion in these conditions is really the point. Difficulty breathing or shortness of breath, tiredness or fatigue, symptoms that get worse after physical or mental activities, known as post-exertional malaise. Haven't heard that since the Carter administration. Difficulty thinking or concentrating, sometimes referred to as brain fog. This is a commonly reported condition, one of the more common manifestations of long COVID. Cough, chest or stomach pain, headache, fast beating or pounding heart, joint or muscle pain, pins and needles feeling, diarrhea, sleep problems, fever, dizziness on standing or lightheadedness, rash, mood changes, change in smell or taste, and changes in menstrual cycle period. Now, there are lots of other conditions that are associated with many of those symptoms. Anxiety disorder, a mild heart attack would include chest pain, fatigue, lightheadedness, some of the other conditions. So if an employee reports as needing accommodation for long COVID, that could mean any number of things, and indeed many different sorts of things at the same time. But there's little doubt that this is a real phenomenon. This is not a make-believe diagnosis or a non-existent condition. It is, however, something that people aren't very sure what to do about, both people who have it and employers who are challenged with potentially accommodating it. So, but before I go on to the legal detail, let me also say that long COVID includes some other conditions that are different in nature from the list of symptoms that I just mentioned. One is multi-organ effects of COVID-19. What am I talking about here? This is an autoimmune condition that results from the immune system fighting a form of COVID, and it attacks particular organs. And this is more easily diagnosed, perhaps, than the various symptoms that I mentioned before. But even then, there's a considerable lack of certainty about what this means, how long it will last. Most people say it will last weeks or months. I have not heard that this could last for years, although I have heard that those other symptoms could last for years. We don't know yet. Enough time hasn't passed. Don't know what variations are more or variants are more likely to give rise to it than others. The other thing besides multi-organ effects are the effects of hospitalization. Now, I think it's debatable whether this is a disability, but anytime you go into the hospital for a serious illness and spend time there, it's often exhausting. You don't get much sleep. You're weak. You haven't exercised. You haven't moved a lot, and you may be suffering from some sort of post-traumatic stress disorder, if only because you were worried about whether you were going to die from the condition or how it was going to affect you and how long it was going to last, etc. So these effects of hospitalization or illness that didn't cause somebody to get hospitalized, but someone was very sick at home. These effects of COVID-19, apart from the other things I've mentioned, are also considered by the CDC to be long COVID. Then there are special situations for children that I'm not going to address today since we have child labor laws. Next slide, please. So what does all this mean legally? Well, the EEOC has said that long COVID could be a disability. It depends. Have to evaluate it case by case. And it has said it could be a disability under any of the three prongs that have long been recognized as covered disabilities under the ADA, really from the inception of the law. One is an actual disability. One is a record of disability. You had the disability before, you have a record of having had it before, but you no longer have it now, it being COVID-19 in this instance, or regarded as an individual with a disability. Again, you may not actually have long COVID, but you might be regarded as having long COVID, especially if you exhibited multiple symptoms that I listed. Now, these different prongs give rise to different legal obligations. There's a duty to accommodate with regard to actual disability, no surprise. There is a duty to accommodate with regard to record of disability, which some people find surprising, and employers resisted as part of the ADA Amendments Act. But under record of disability analysis, accommodation may make sense. For example, if someone suffered serious scarring, they're no longer impaired in a way that affects the major life activity, but still they may be embarrassed by that. They may or may not want to be visible to others. Some people insist on being visible to others, and that can cause issues itself. But in either of those instances, there is a duty to accommodate. Conversely, if you're only regarded as disabled, presumably by the employer, that's the legal issue we'd be concerned about. If you're regarded as an individual with a disability, there's no duty to accommodate because there's nothing to accommodate. It's just the employer's misperception. That may need to be changed, but that's not an accommodation, not in EEOC's view. Still, that's a nice, clean set of definitions that have always been the case under the ADA and before then under the Rehabilitation Act. But so how will that work? I'm frankly not sure. For example, if someone at work had COVID-19 and they're now manifesting symptoms, they're lethargic, they're weak, they don't move as quickly as they did, and they seem unfocused. Brain fog may not be a term that the employer is familiar with, but the employer seems to be concerned that the person is not focused on work and staring into space and unable to concentrate, or at least has difficulty concentrating. So if the employer sees someone that way, and in fact someone is behaving in those ways or suffering from those conditions, is that a record of disability? Probably, if they had been diagnosed as regarded as disabled. Well, the employer might say, no, I didn't know anything about them having COVID, or I don't care one way or another whether they had COVID. All I know is that they are seemingly lethargic and weak and not focused. I'm just regarding them as being a subpar performer. So these will be issues in litigation, no doubt. Again, the EEOC has said what you would expect it to say, that the determinations will have to be made case by case, and it will depend on duration, although even temporary conditions can be disabilities. I think some lasting a couple of weeks won't be, but some lasting a couple of months certainly could be. Severity, that's the degree to which it substantially impacts a major life activity, or whether it does substantially impact a major life activity. So these are going to be viewed as individualized situations. Of course, the employer can require proof if somebody wants to be accommodated, and I'll talk about that. There's also guidance on this, not a lot more helpful, frankly, from the DOJ and HHS, which have addressed it as a potential disability and said it is a potential disability under ADA Titles 2 and 3, as well as Section 504 of the Rehabilitation Act, which the DOJ oversees. So, there is that legal authority. It's not very helpful, though, I have to tell you. Next slide, please. How might you accommodate this? Well, first of all, remember that the usual ADA principles do apply. The employee must generally request accommodation. If an employer is observing someone manifesting, experiencing some of the symptoms that I've listed, I think just about the last thing it wants to do is go ask the person if they might have long COVID. Hey, have you thought you might have long COVID? Not a good idea. On the other hand, you can't bury your head in the sand. If you, the employer, know that the person did have COVID, they're manifesting some of those symptoms, they didn't before, then you may have a duty to approach the employee and ask if they need an accommodation, even if they haven't requested one. That's a long-standing ADA principle, but what do you do in this situation when the symptoms are just about anything and everything that could be wrong with somebody? The suggested accommodations from the EEOC include schedule changes, like maybe letting people not work when they don't feel like working. Usually the EOC doesn't say that. Usually the EOC says that is not required. Many of these conditions are not predictable. They're sporadic. They may go away for a month and then they may recur. They may continue after COVID and then dissipate. They come in all shapes and sizes, which is why it has to be evaluated case by case. Other suggestions are special or modified equipment. For example, with breathing difficulty, letting somebody bring an oxygen tank or other breathing assistive devices into the workplace seems to be a logical and reasonable thing to do. Now, the CDC has also chimed in on accommodation, which is interesting, but not all that surprising. You have to remember that throughout the pandemic, the EEOC looked to the CDC as authoritative in the C-19 space, and that was really true at all steps of the pandemic, and transcended both the Trump and Biden administrations. So the EEOC guidance has long said to look to the CDC guidance. The CDC doesn't like to step on EEOC's toes, but they do have to try to figure this stuff out, and they will occasionally give some tips to employers. Their statement about possible accommodations is flexible leave, which to me, being somewhat cynical isn't the right word, but confused about what that might mean. Sounds like it might mean I need to be off when I don't feel well or I'm not able to focus on work. And that could be without a lot of notice to the employer, which could be an undue hardship or simply not a reasonable accommodation. Schedule policies, which may make sense if somebody's more tired at certain times in the day. Conversely, if they just need to be off when they need to be off, that's not much of a schedule policy. I'd say it's a lack of a schedule. And providing access to employee assistance programs, says the CDC, which is interesting. I think that that's a reference to the mental challenges that are either one effect of, symptom of, or consequence of this condition. Depression, confusion, anxiety. When is this going to end? I thought it was over. I thought it was over for me. I thought it was over for the country. Now I've got it, or something like it. Very, very difficult for people emotionally, and I think it's in that context that the CDC is suggesting employee assistance programs. Next slide, please. So I've listed here two other resources. The EEOC information, by the way, is in their ongoing technical guidance. What you need to know about COVID-19, which has really been quite helpful at many junctures. Less helpful, I fear, at the long COVID stage, at least for now. But that is the nature of the conditions. So you can find that there at section N. It is the most recent section in the EEOC guidance. And then these two CDC sources are helpful. The first one, post-COVID conditions, which was last updated last September, contains a sort of step-by-step process of communicating with people about long COVID, whether they may have long COVID, what they could do about long COVID, really just a springboard for discussing long COVID. Yet the CDC identifies this as a means of accommodation. In fact, they say that employers can support employees experiencing post-COVID conditions by offering flexible leave and work schedule policies, like I mentioned earlier. So this is a piece that's intended for the public at large. It's not directed at healthcare professionals, and it's not directed necessarily at people with long COVID, but it's directed at America and at employers specifically, in part. The other piece that I found interesting, and it's the most recent piece from the CDC, is caring for people with post-COVID conditions, which of course is not the employer's responsibility literally, but it is a helpful up to the minute resource on what can and can't be done about COVID-19, and it too speaks to employers and what they may do or want to consider doing. This is going to be a great challenge when it arises. I'm not sure it's going to arise that frequently. If people claim many of the symptoms that I've identified, or more precisely CDC has identified, as associated with long COVID, quite frankly, they may not be able to work. At least they may not be able to work regularly. And that's a societal concern, an economic concern, and certainly an individual concern for affected employees, and their employers. But you know, it's a real gray space. And the last thing I'll say for the litigators out there, or reformed litigators, if some of you are like that, is that fact questions. Is it a disability? Fact questions. Lots of fact questions. Can it be accommodated? Maybe for a while. Wait and see. Fact questions. Undue hardship depends on how long it's going to go on. Nobody knows. Fact questions. Fact questions. Fact questions. Fact questions. Summary judgment. Good luck. That's all I have to say about long COVID. Thank you.
This concludes today's webinar. The CLE code for this webinar is SS, as in Seyfarth Shaw, 3993. Again, that is SS 3993. Thank you for attending.